talking to in conversation with Senior Advocate Fali Nariman. My next question to you, Fali, is that pointing and talking about the case of Justice CS Karnan of Madras High Court, who was punished for 6 months imprisonment. You have on one hand pointed at his persistent and repeated defiance of the Supreme Court, the judgments of the Supreme Court, and he also made unsubstantiated allegations against the judges. Yet in the book, Before Memory Fades, an indication is given that the judgment set a bad precedent.
Very bad precedent.
This requires a little elaboration.
Explanation, yes. You see, I wrote my 4th book, God Save the Honorable Supreme Court. And that's what I titled it. And I titled it because in the United States, whenever the Supreme Court, with its bench of 9 judges, they have no more than 9, no less than 9, assembles every morning on whenever they are in session, the clerk of the court always ends a little bit of introduction by saying, God save the Honorable Supreme Court.
Yes.
Expressly.
Yes.
In my book, I have also called the opening lines of that historical masterpiece of Charles Dickens. It is of the year 1859, called The Tale of Two Cities. The great masterpiece begins with this sentence, and I'll read it to you. It was the best of times, it was the worst of times, it was the age of wisdom, it was the age of foolishness, it was the spring of hope, it was the winter of despair. In the book I have cited several cases decided by the Supreme Court of India to show how it was the best of times.
Yes.
And by contrast, how in certain other decisions of the Supreme Court, it was the worst of times. And in my view, the decision in Justice Karnan's case was when it was in the worst of times.
The lowest ebb.
Yes. You see, it was the most difficult year, 2018, for the Supreme Court as an institution of judicial governance. And you must read the book, and then you will know why. I have, for instance, written, and this I quote, Jeremy Bentham, the 18th century reformer of law and politics, was a staunch proponent of enacted law. He was an avowed, lifelong enemy of judge-made law. Judge and co is how he disparagingly characterized the country's highest court in his book. And centuries later, David Panic, QC, who's still alive, he writes, the way in which Judge and Co is run is a matter of interest always and at all times, and will increasingly become a matter of public debate. Mark these words. The way in which Judge and Co, Judge and Co is a disparaging term.
Yes.
Judge and Co, like the Supreme Court, Judge and Co is run is a matter of interest and increasingly will become a matter of public debate. It has become.
The functioning of the Supreme Court, it has become.
That's right.
Yes.
In India, in recent years, the way in which the Supreme Court has been run has become not just a matter of interest and debate, it has become a matter of acute controversy, causing widespread concern. A pity indeed, simply because it has left us all wringing our hands in the winter of despair, as Dickens had written in that opening sentence.
It has eroded the credibility of the court.
That's it.
Yes.
I suggest that in desperate times like these, or like those in 2018 when public confidence in the highest court was at an all-time low, it would not be inappropriate to amend the last sentence of the traditional chant in the US into a single impassioned prayer on the lips of all citizens, God save the Honorable Supreme Court. And the example I have given of the worst of times is in the case of Justice Karnan, where the Supreme Court of India held a judge of the High Court guilty of contempt, which I believe is not contemplated by the Constitution or by the Contempt of Courts Act. A High Court judge can never be subjected to the indignity of a contempt. He may be removed by the procedure prescribed in the Constitution, and that is the only known method of getting rid of his secure tenure. Otherwise,
of dealing with the judge, if I can say,
yeah,
in sort of simply.
Yes.
So, you are of the view that ultimate that can be done against a judge for his...
Who is appointed? Please remember,
yes,
judge who is appointed.
Appointed.
Therefore, you have to be very careful whom you appoint.
Yes.
But once you appoint him, you are stuck with him. He is round your neck.
Yes. And the only
You
method
can remove
is
him.
impeachment.
But that is for
Yes.
misconduct.
Misconduct.
So you have to point out something against him. And there is
Yeah.
no other known method to get rid of him, just because you don't like him or you don't like his judgments. Makes no difference. You see, that's the bitter pill we all have to swallow. Otherwise, you can't have an independent judiciary.
For inefficiency and undesirable conduct, there is no...
There's no,
Yes.
there's no hope. There's no
Yes.
hope. That's why very important how you...
Yes.
You see, you are mentioning this undesirability.
Undesirability.
I'll tell you an instance that
And
happened
inefficiency,
when
yes.
I was practicing in Bombay in the High Court. We had a very brilliant Chief Justice, Justice Chitatosh Mukherjee.
Okay.
Chitatosh Mukherjee was the grandson of Sir Ashutosh Mukherjee,
okay.
the first Chief
Yes,
Justice
first
of
Chief
Calcutta
Justice,
High Court,
yes,
Indian
yes.
Chief Justice of
Yes.
Calcutta High Court. Brilliant man and very, very
Yes.
astute.
Yes.
There were a group of about 100 lawyers who filed a written application with complaining against 4 judges of the Bombay High Court at the time.
Yes.
This was years
Yes.
ago when he was Chief Justice of Bombay. When this complaint was presented to him, he said, yes, leave it here, I'll see to it, I'll see what I can do. He studied it, made inquiries himself, and after 2 weeks, he devised a remedy. He found that the allegations were correct,
Yes.
and what he did was, he just did not give work to these judges.
No work was assigned.
No work was assigned because the
Yes.
Chief Justice is the master of
Master
assigning
Justice,
work.
yes.
Every day they'd come
Yes.
to court in their dress of their bands and gown and all that, but there would be no court for them because the court would not sit.
Yes.
There was nothing listed.
Yes.
It was not on the list. And the Chief Justice is in charge of the list.
Yes.
So, a lot of lawyers complained, the judges complained. He said, please, go ahead and file a writ petition
Yes.
on the judicial side, and I'll have it heard by an independent set of judges in my court.
Yes.
And whether I'm right or I'm wrong.
But he stuck to his
But he
decision.
stuck to his
decision.
and that was a great
Yes.
remedy. I always call it the Bombay Experiment.
The Bombay Experiment,
Yes,
yes.
it has never been tried again, unfortunately.
Yes.
You see, instead of transferring all these judges from one court to another,
Divest them of the work.
divest them of the work. Ask the Chief Justice if you are certain.
Yes.
Just ask them not to do that work. And then they are entitled to file on their own complaint. That matter has to be investigated. It will be done according to law. So there is no impediment of law. And that, to my mind, is really the remedy. That's why when there is now a complaint, great complaint,
Yes.
even today,
Yes.
about 48 judges having been transferred from one court to another, one high court to another high court, presumably on charges of
Yes.
apparent
Yes.
misbehavior, apparent misbehavior. Either you impeach them
Or this is
you don't give them the work and ask them to move the court, saying how important they are, because that's the only remedy available. There's no other remedy.
It may also put them to shame, and someone may sort of put in papers.
Yeah, put in his papers. But if he doesn't put in his papers, he is entitled to say no. I am totally right, and the Chief Justice of the High Court is wrong.
Right.
So
I think this is something brilliant, and this shows a way.
That shows
as you said,
some
the Bombay
sort of way
Experiment.
which is available. The Bombay Experiment not been tried at all, and it's very unfortunate. So I personally think that a High Court judge can never be removed for contempt. He may be removed by the process prescribed in the Constitution, and I have expressed a hope that this never happens again. This never happens again, and I hope it doesn't happen again. But of course, this judge was a total cranky person, so it's very difficult to have. But that's where you have to be very careful when you appoint the man.
And Constitution is not really helpless, as you have shown that Bombay Experiment.
The Bombay
Experiment. There is a remedy.
Yes, that is the genius of this judge, Justice Chitatosh Mukherjee. I was very fond of him. Yeah.
Thank you very much. And we come to the end of this video. And in the next video, we would take up a very interesting situation where Fali would be requested to recall the conversation in the court, or the address to the court by, on one hand, Nani Palkhiwala and Kanhaiyalal Mishra on the other. Thank you.